Hi.
Why don't you tell me about your assignment?
Sure, actually here I brought you a draft.
Oh, thank you. Okay.
So my assignment is to write a memorandum in support of a motion for preliminary injunction, but I'm not quite sure how to begin. In fact, I'm not even sure what a preliminary injunction is.
Well, a preliminary injunction is a form of equitable relief. In order to bring a motion for a preliminary injunction, there has to be a complaint on file. So what often happens is a party files a motion for preliminary injunction at the same time that the party files its complaint.
Okay.
There are other types of injunctive relief as well. There are TROs, temporary restraining orders, and permanent injunctions. If you're interested in learning more about those, you can check out our module on injunctions.
Sure.
Federal Rule 65 governs preliminary injunctions in federal court.
Right.
In Illinois courts, Section 511-101 governs injunctions. Illinois requires a party to establish 4 things. In federal court, the court considers a 2-step analysis that shares some common elements with the state requirement. Once the moving party establishes irreparable harm, that the harm can't be repaired, inadequate remedy at law, that money damages are not sufficient, and a likelihood of success on the merits of the underlying complaint, then the court considers a balance of the harms that either party might suffer and considers the effect the injunction will have on the public interest.
Sure.
Now let's talk about your assignment.
Sure. Okay, so we represent a prisoner who is alleging that the defendant prison is violating a federal statute. The prison is denying him religious items he needs in order to practice his religion. Our professor said that we are filing the motion in federal court and that federal law applies to the cause of action.
Okay, so that means that Federal Rule 65 is going to govern the procedural aspect of your motion for preliminary injunction. Okay. Federal statute will govern the underlying statutory violation claim. In some cases, the underlying cause of action might be a state law claim. In that case, even though the case is filed in federal court, that state law will govern that cause of action. Right. An example of this might be a cause of action alleging defamation. In that case, Federal Rule 65 would govern the motion requirements, the procedural requirements for the injunction, but state law, Illinois law maybe, would govern the cause of action for the complaint for defamation.
Sure.
That'll become important when we talk about organizing your memo.
Okay.
So with your client, the prisoner, Federal Rule 65 is going to tell you what you need to establish to succeed on the motion for preliminary injunction. That federal statute is going to tell you what your client needs to establish for that statutory violation. Right. So let's talk about those first 3 things a party has to establish in order to succeed on the motion.
Sure. Okay, so there will be the irreparable harm, the inadequate remedy at law, and a likelihood of success on the merits.
Right. These 3 elements comprise the first step of that 2-step analysis the federal courts will consider. These sound like the first 3 main sections of your memo.
Right.
Does your professor prefer a certain order for how you tackle these elements?
He said we might want to tackle likelihood of success first because it will probably be the most extensive part of our memo.
Okay, so let's discuss that first.
Sure.
What does Rule 65 say about likelihood of success?
Basically, the movement has to show that he will probably win on the underlying cause of action. Now, some courts have said that the plaintiff's chances have to be better than negligible. So in our case, we have to argue that the plaintiff has a better than negligible chance of proving his statutory violation claim.
Okay. After you set out the rule for likelihood of success and discuss how courts may have interpreted that phrase, you're going to want to set out each element of that statutory violation as a subsection of your likelihood of success portion of your memo.
Sure.
If you had a state law claim for your underlying cause of action, like defamation, then your subsections would be made up of the elements of defamation.
Right. Okay. Makes sense.
Don't forget to address any defenses the defendant may raise to that underlying cause of action.
Okay.
So once you complete your likelihood of success section, what will the next section be?
Right. Either irreparable harm or inadequate remedy at law.
Okay. So let's do irreparable harm. What does Rule 65 say about this?
Not much.
Okay. Well, you may find some cases that discuss that phrase and what it means. In the meantime, you'll need to argue that the harm suffered by your client cannot be repaired if the client doesn't get the injunction ordering the defendant to stop denying those religious items.
Okay.
If you were representing the defendant, you would argue that if there is any harm to the plaintiff, it can be repaired somehow.
Sure, okay. And the third element then is inadequate remedy at law. This proves to the court that money damages or damages at law are insufficient.
Right. While the plaintiff might ultimately be awarded monetary damages, you want to argue that those won't be sufficient because being awarded money alone will not adequately compensate the plaintiff for harm done.
Okay.
Of course, the defendant would argue that if there is any harm, the plaintiff will be compensated by monetary damages if warranted.
Sure. My professor said that we can combine the irreparable harm and inadequate remedy at law elements into one section.
Okay, if you do that, make sure you've discussed them the way we've talked about them here. And you may want to confirm that with your professor. Some professors like to see those sections combined. Others like to have them broken out separately.
Okay.
Now that you've completed the first part of the two-step analysis, what comes next?
Sure, so that would be the balance of hardships and the effect on public interest.
So those sound like two more main sections of your memo. Or maybe your professor has said you can combine those sections as well.
Okay.
In either case, let's talk about the balance of hardships. When drafting your memo, ask yourself, what harm will the plaintiff suffer if the court denies the injunction? In other words, in your case, what will happen to the plaintiff if the court doesn't order the defendant to stop denying those religious items? Next, ask yourself what harm the defendant will suffer if the court does grant the injunction. In other words, in your case, what will happen to the defendant if they're ordered to stop denying those items to the plaintiff? And why would that be bad for the defendant?
Okay.
Then discuss who will suffer the greater harm based on the court's decision and how the court should consider that when arriving at its decision.
Okay. And the last thing I then have to address is public interest.
This simply means that the court should consider any impact its decision will have on the public. Try to identify what interest the public may have in this case. Ask yourself what interest they may have in the plaintiff's situation, and then what interest the public may have in the defendant's situation. You can be creative here. Try and think of some big picture, current issue arguments that you might make on behalf of your client. Are there any constitutional considerations you can invoke? How might the court's decision affect society at large? After a little more research, do you think you'll be ready to revise your draft?
Yeah, definitely.
And please come back and see us at the Writing Resource Center if we can help.
Great, I will.